It's passed vacant.
Good.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he...
Right from the start, the judge makes it clear there's no room for excuses. A defendant misses their scheduled appearance, and immediately, she orders the bond to be forfeited. It's the court's firm reminder that when you're required to show up, the obligation isn't optional. But pay attention, even with that firm stance, she still allows room for fairness. If the defendant walks through those doors before the hearing wraps up, she's prepared to reverse the forfeiture. It's a moment that shows how the justice system can enforce responsibility while still considering circumstances. Accountability and fairness, both on full display within the very first minutes of this hearing.
having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis and, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to.
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine? And this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge. And we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoppower call because he's used.
The defense explains that delays with CPS records are slowing everything down, and anyone familiar with the system knows this is nothing new. These records can take ages to process, dragging cases out far longer than they should. The judge acknowledges the issue but emphasizes a crucial point. Without those documents, the court simply can't proceed. It's like trying to finish a puzzle with missing pieces. So she makes it clear, the request needs to be completed, and quickly. Her message to CPS, though wrapped in polite judicial language, is unmistakable. Let's move this along. The court is waiting.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to them by email, Stephanie.
Okay.
Adams, but we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me
expect
an
them?
update, but it was Friday.
Okay.
when I got last contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoppower's voicemail. Sound about right? 2 minutes, what, please?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
Sometimes, the lighter moments inside a courtroom say just as much as the serious ones. The judge makes a quick, clever remark, nothing harsh, just enough humor to break the tension, and the entire room shares a laugh. For a few seconds, the heavy weight of legal process fades away. It's a simple reminder that even in a high-pressure environment filled with deadlines, responsibilities, and real consequences, the people involved are still human. Judges, attorneys, defendants, everyone is doing their best to navigate a complex system that can feel overwhelming on the toughest of days. These flashes of levity help reset the tone, allow everyone to breathe, and prove that courtrooms aren't always about confrontation. Sometimes they're about connection, recognizing that justice isn't delivered by cold procedure alone, but by real people working through challenges together.
You can handle it.
Next game.
Mr. Rojas, you've got Carnell Beard. Good morning, Mr. Rojas.
Morning, Your Honor.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Are we going on count one? Oh, no?
No, ma'am.
Okay.
Everything.
Okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony, Well,
Judge, I'm
do we
looking
just
at
need
the
to go on one, or
Let's
is
just
that?
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
It
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is
Now we arrive at a major legal turning point in this case. The judge brings up what's known as a felony enhancement, triggered when someone has prior felony convictions on their record. What does that mean in plain terms? The new charge automatically moves into a higher felony category, increasing the potential punishment significantly. It's the legal system's way of saying, this isn't a first-time situation. The stakes are now much higher, so instead of facing a standard sentencing range, the defendant suddenly sees those numbers escalate. What could have originally carried a few years behind bars now stretches into a much longer possibility, turning something like a 2 to 10 year window into a daunting 2 to 20 years. Enhancements like this can change the entire strategy of a case. One decision in the courtroom, and the future looks very different for the defendant sitting at that table.
between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for a pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced,
15
but,
and 99 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain.
Now the court delivers a serious reality check. Habitual offender status is on the table. This isn't just an enhancement, it's a game changer. With this designation, the legal consequences escalate dramatically. What might have been a standard sentence now carries a mandatory minimum of 25 years, sending a clear message about the severity of repeated offenses. The judge isn't issuing threats, she's laying out the facts, showing the defendant exactly what the law prescribes. It's a sobering moment that underscores how prior convictions can transform the stakes in a case, and why the courtroom demands attention to every decision made along the way.
Section here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement, unless there is new information that your attorney or the district attorney's office receives. Do you understand? Okay. If you'll just have a seat, she'll call you up in just a minute.
This case reminds us that justice isn't just about rules. It's about accountability, procedure, and integrity. Even the most experienced attorneys must respect the court and follow the law. Judges like Phyllis Webster show that knowledge and composure always hold the upper hand. Every procedural step matters, and no one is above the system, no matter their title. For viewers, it's a lesson. Understanding your rights and respecting the process protects everyone. Stay informed, stay aware, and remember, the courtroom rewards preparation, professionalism, and principle.